Welcome back to Case Law Stories to relax and fall asleep to. Tonight we step back to the earliest days of the American Republic. A time of candles, parchment, and power still being defined. This is the story of Marbury versus Madison, the case that planted the seeds of judicial power in the quiet halls of a young Supreme Court. So lay back, let the day slip away, and drift into the warm flicker of 1803. Washington, D.C. is still raw and muddy, a new capital not yet settled. Its streets are lit by lanterns, its government young, ambitious, and tense. President John Adams, a Federalist, is about to leave office. His political rival, Thomas Jefferson, is about to take his place. On his final night in office, Adams is busy, very busy. He appoints dozens of loyal Federalist judges in what history would call the Midnight Judges Act. One of those men was William Marbury. Adams signed Marbury's commission to be Justice of the Peace for the District of Columbia. The appointment was sealed, the paperwork prepared, but in the rush of the transition, the commission was never delivered. And the next day, power changed hands. Jefferson refused to honor the appointment, and he ordered his Secretary of State, James Madison, to withhold the commission. Marbury, outraged, filed a petition directly with the Supreme Court. He wanted the court to issue a writ of mandamus, a court order compelling Madison to deliver the commission. And that is how this quiet, clerical oversight became a case that would define the very shape of American law. The court was led by Chief Justice John Marshall, a man of precision, gravity, and vision. He had a choice before him: rule in favor of Marbury and risk a direct political clash with Jefferson, or rule in favor of Madison and let the executive override legal process. But Marshall did something more, something elegant. His opinion was measured, deliberate, historic. He began by laying out the law. Yes, Marbury had a right to his commission. Yes, Madison was wrong to withhold it. But then, Marshall turned to the real issue. Could the Supreme Court issue a writ of mandamus under the Judiciary Act of 1789? He examined the Constitution, and quietly he said, no, because that portion of the Judiciary Act conflicted with Article 3 of the Constitution, and when a law passed by Congress conflicts with the Constitution must win. With a calm, unwavering voice, Marshall declared, "It is emphatically the province and duty of the Judicial Department to say what the law is." And with those words, the court gave itself the power of judicial review, the power to strike down laws that violate the Constitution. Marbury lost the case, but the Supreme Court gained its voice. Let the story settle in, let the lesson linger. Marbury v. Madison reminds us that law is more than rules. It's structure, balance, and the quiet courage to draw a line even when it risks power. So as you close your eyes and drift into sleep, remember that the courts don't raise swords or spend treasure. They whisper, and through that whisper, they shape the meaning of our deepest principles. Good night. And thank you for listening to another case law story to relax and fall asleep to. We'll see you soon.